Hello, thank you for joining us. We're really excited to be here representing our organization known as Bella. We support Latina women entrepreneurs and small business owners in the city of Los Angeles. Thank you, Nadia, and your team at Tzedek for partnering with us. One of many workshops we will do to help our community understand the legal aspects of running a small business. So I'm here to say thank you. I'm here to welcome you all, and I'm sure there will be a lot that will be learned today. Nadia, I'll hand it over to you.
Thank you, Rocio. Hi, everyone. A little bit of just housekeeping before we start. If you want to listen to this presentation in Spanish, we ask you to select the Spanish channel on the bottom of your screen. You can select Spanish or English. So if you want to hear into Spanish, select Spanish. If you want to hear in English, select English, please. And I'm gonna go ahead and share my screen to start just providing an introduction of Tzedek and the services that we provide through the small business program. So Tzedek Legal Services is a nonprofit organization that has been assisting Los Angeles County for over 40 years. We provide free legal services to small business owners and entrepreneurs and to individuals in a wide range of areas. The services that we provide, I provided regardless of an individual's race, religion, ethnicity, or immigration status. Today, in specific, we are going to focus on the work that we do through the Small Business Development Project. So the Small Business Development Project focuses on helping low to moderate income entrepreneurs and small business owners to secure free legal assistance in a variety of transactional legal issues. We provide community presentations and workshops like this one. We also provide our small business legal academies. We provide guides and free resources that are available on our website. And we also provide direct client representation. The areas in which we can help a small business owner can go from helping someone to review a contract or a lease agreement. We can also help commercial tenants to review their agreements or to negotiate with landlords. We can also help with issues related to intellectual property. So we can help small business owners to file for a trademark or a patent, a copyright. We have lawyers in our team that can help you directly. And we also partner with law firms. We're always very grateful to have pro bono lawyers that help us. So depending on the type of services that you may need, we will either help you directly with someone from Tzedek, or we will find an expert that will provide the services for free. It is very important to mention a couple of things related to our eligibility criteria. We focus on helping for-profit businesses in LA County. So if you are a nonprofit organization, that's outside of the services that we can provide, but we can refer you to other organizations that help nonprofits. The other thing that is very important to mention is that we don't help in litigation issues. What that means is that we can help you with transactional matters, as I mentioned on the previous slide. But if you are already in litigation proceedings, we cannot assist you, but we will provide resources and connect you with lawyers that may be able to do it. And then besides that, we also have a specific criteria regarding the income of the small business owner and the profits and sale of the business. So once you apply to receive services from us, we will assess whether you qualify to receive these free legal services. How you can get help. So the first step for everyone is to apply to get the assistance, and that's through that link. I'm going to include it on the chat so everyone can also just reach out to us. I know that when some people register, they mentioned that they wanted to receive a free consultation from an attorney, so we will be reaching out to you. My email is also there. And then on the first link, you can provide, like you can receive the free resources that we have available on our website. And now we are gonna move ahead and start the intellectual property presentation. We are very grateful to have Ron. He's a counsel in the corporate practice of Paul Hastings, a law firm that is based in Los Angeles. He focused his practice on intellectual property and has over 20 years of experience working with different small businesses and businesses in general. So we are very, very grateful to have Ron with us today. And
Good
then,
evening. Oh, sorry.
one more slide, Ron, before we move forward with you.
Sure.
Before we start, we have to just mention that the information that we are going to provide today is for education purposes. So nothing that is said today is considered legal advice. If you decide to get legal assistance, we recommend that you reach out to an attorney. You can reach out to us at Tzedek to connect you with an attorney. But nothing that is said today should be considered as legal advice. It's only for educational purposes. I'm going to stop this presentation. And for those people that just joined, what I mentioned is that you need to select the language in which you want to hear the presentation. So you can select on the bottom where you want to hear it in Spanish or English. So please select the right one. And I'm going to go ahead. Okay, so I'm going to go on mute and let Ron start.
Good evening. When we think about property, we usually think about real property, land, or personal property, like a car or a computer or a piece of furniture. But intellectual property, even though it's not something you can touch, it's just a collection of legal rights, is extremely important in the modern economy. And it offers businesses today tremendous opportunities and also significant risks. So it's very important to have an understanding of intellectual property if you're running a business. There are four main types of intellectual property. And if we're all on slide 3, those are trademarks, copyrights, patents, and trade secrets. And we're going to discuss those in greater detail. But at a high level, just to start, a trademark is a name or a logo, something that identifies a particular business, right? So Apple is a trademark for Apple computers, right? Pepsi is a trademark for Pepsi Cola. A copyright is a legal right in something creative. It's called a work of authorship. It could be something that you write, like a book or an article or a blog post or a script for a motion picture. Also, it could be software. Software is something that's written that's protected by copyright. It could be a work of visual art, like a painting or a photograph. Or an audiovisual work, such as a motion picture or television show, right? So it's something creative. For trademarks and copyrights, the government has a system in place where you can register in order to get, you can register those things, but you don't have to. You get them automatically. So when you use a name in connection with your business, you automatically develop trademark rights in that name just because you use it, as long as you use it in interstate commerce, in commerce that, or trade that goes beyond just the borders of one state. With copyrights, if you create, like I said, a photograph or a painting or some kind of written material, or music, or software, the copyright exists automatically. You get the copyright automatically as soon as you write it down or save it to disk or otherwise, record it in some kind of media. So that trademarks and copyrights. Patents, Patents are rights in technology, different kinds of technology, that don't arise automatically. Those you have to apply for, and it's an extensive and potentially expensive process. They're more important for industries that are more in the technology sector, like the computer industry or pharmaceutical companies. And the last one is trade secrets. Trade secrets don't have a registration scheme. You just get those because you have a secret that's important to your business. And we'll go into those in a little more detail. So let's go to the next slide, slide number 4. IP concerns for small businesses. There are really two main reasons that it's important to understand a little bit about intellectual property. The first is to protect your investment in your business. Understanding intellectual property and protecting it can help build value for you, right? It can help you maintain and enhance a competitive advantage in your industry. So that's the first reason. The second reason is to avoid liability. If you don't understand intellectual property, you may inadvertently infringe or violate intellectual property rights of others, which could lead to liability, right? You could get sued for that. So it's important to understand intellectual property, both because you want to build value in your own business and because you want to avoid doing anything that could get you sued. Okay, let's go to the next slide. So now we're going to go into the various kinds of intellectual property in a little more detail. And the first one is trademark law. So I'm going to slide 6. Trademark law arises under something called the Lanham Act. It's federal law. And it protects anything that could identify a business. So that could be a word, like, a name, like I mentioned, Pepsi and Apple. It could be a symbol, such as a logo. The purpose of the trademark law is to protect the public, right? If there's somebody out there selling a computer and they put the Apple logo and name on it, and I think it comes from this company that I've bought a lot of stuff from and I know them, the law wants to protect me from being fooled essentially by somebody who's pretending to be someone else, right? Pretending to be Apple and selling a computer, or whatever, right? Pretending to be Coke when they're selling a soda. The term of the trademark of trademark rights is perpetual. Once you have a trademark, as long as it continues to identify your business, then you continue to have rights. It's different from some other kinds of intellectual property, particularly patents, that only last for a while. And then trademark rights, like pretty much all intellectual property rights, are specific to the particular country you're in. So if you operate outside of the United States, then you need to learn about the trade or the intellectual property laws in those other countries. Next slide, 7, is just an example of some trademarks, names, logos, etc. Slogans like "Just Do It," for Nike, that can also be a trademark. Going on to number 8. This is getting into a little more detail than you probably need, but it talks about the different kinds of protection under the trademark law. A trademark is a name or other, mark for goods, something physical. A service mark is the same thing, but for services. The other ones are not as important, I think, for your purposes, so we can go on. Number 9, choosing a mark. So there's there are a number of steps that you have to think about when choosing a mark. The first is, you want your mark to be strong. So one of the important things, once you have a trademark, you want to prevent others from using your trademark, right? You don't want, so if you start to build goodwill, right? Let's say you have a restaurant or some kind of service, and your customers start to get to know you and they start to rely on the quality that you regularly provide. They're going to want to know when they see that mark that they're really working with you. And so you want to prevent your competitors from confusing them, by using the same mark or a similar mark. And different kinds of trademarks or different qualities of trademarks are strong. Some are stronger and some are weaker. Stronger means that anything that's even close might still be infringement. Whereas a weak mark means that, yeah, you have a mark, but if somebody, copies it almost exactly, but not exactly, they may not, they may be able to get away with that. Marks that are very descriptive of the business are not protectable at all, right? Because everybody has to be able to describe their business. So for example, if you sell televisions and you decide you want to call your store the TV store, you probably can't get that protected because it just describes what you do, right? There has to be, it has to be more than just purely descriptive. If there are marks that aren't so descriptive, but they're kind of suggestive. They say something about the quality of your goods. And those are protectable, but they're kind of weak. And then there are marks that are entirely what they call fanciful, like Xerox for copiers. And those are strong marks. Those are highly protectable, including against marks that are not identical. All right, let's go to the next slide, slide 10. When deciding on a trademark, so you've done the first step, you've tried to come up with a name that's not too descriptive, and that you think is going to be, good for your business, that that you can protect. But then you have to figure out, well, is it available? Is there already somebody out there using it? And the things to think about in that case is that, is somebody using a similar name or similar logo or similar mark to sell similar or related goods or services, right? If the names sound really different, you're probably fine. If the names sound, maybe somewhat similar, but they're in completely unrelated businesses or markets, you're also probably fine. And the reason is that probably in those contexts, no one's going to be confused, right? Trademark infringement arises if somebody uses a mark in a way that confuses the public, confuses the public about the source of goods. So you need to see what, it's important to determine how the mark you want to use or something similar is being used in the market. And you can look for that. I mean, you may know it to some extent just because it's your industry, but you can also search. The US Patent and Trademark Office has a website where you can perform electronic searches of the trademark database. You can search domain name registries. No, you should keep in mind that trademarks and domain names are not registered. It's not, they're different. They're not registered in the same registry. And this may be a little expensive, but there are services that will do very professional trademark searches for you, much more. They have computer programs that were designed specifically to try to find potential problematical trademarks that might be used, that you would infringe. And for a few $100s, you can conduct a trademark search through some of those. All right, next, that's trademarks. I don't know if there's any way for us to, I guess there's no way to take questions on this, maybe after at the end, I don't know.
Yeah.
All right, let's go on to copyright.
Yeah.
Yeah.
We usually wait to answer questions at the end. So for those people,
Okay.
you can either send the question on the chat, and we will read them at the end. So yeah, please wait at the end of the presentation.
Okay. So now slide 12, copyrights. So copyrights are essentially the rights of authors or artists or musicians or musical composers, in the creative works that they create, or the rights of software programmers or software companies in the works that they create. Now, one thing that's not in these slides, but it's worth mentioning now, and I'll mention it, and it applies not just to copyrights, but to others as well. It's very important that whenever you work with people who might create something for your business that could be protected by intellectual property, that you have a written agreement in place with them. So for example, if you have an employee, somebody who works for you full time, and they create something that's, you know, like a blog post or some kind of piece of art or something, or so they write something in the course of their employment, as the employer, you would own it. But what a lot of people don't know is that if you hire somebody as an independent contractor, not as an employee, to prepare something for you, even though you pay them to do it and they prepare it for you, at the end of the process, they would own the copyright, not you, unless you have a written agreement in place that says otherwise, that says that they're assigning the copyright to you, or that the copyright will be deemed to be a work made for hire, right? So that's often a trap for the unwary. A lot of small businesses who don't have a lot of experience with intellectual property, you know, hire somebody to design a logo for them that might be copyrightable, or to write a pamphlet for them, or to take photographs that they use in their business. In all of those cases, the company that hired that person would not own the copyright in the work that was prepared unless there was a written agreement in place. Other times, a written agreement is very important. We haven't discussed trade secrets yet, but it's very important that whenever you have an employee or an independent contractor that might have access to information that you view as confidential, then you need to have them sign something in writing that that says that they'll keep it a secret, that they won't disclose it, and they won't use it except in the context of your business. And that happens a lot, right? I mean, if you hire somebody to help you with something, to work with you in your business, you may need to give them access to some of your confidential information so that they can use it in providing services to you. But in that event, you need to protect it in writing. And I know that patents aren't likely to be as significant for most of the people on this call, because that's more for, you know, technology heavy businesses. But also in the case of patents, whether it's an employee or an independent contractor, in order to be sure that the company owns any patents, patent rights, and any inventions that are created, it's very important to have written agreements in place. The term of copyrights is, for all practical purposes, forever. It's very long. I mean, you know, if somebody creates a copyright, the copyright will last long after the author is dead, basically, right? They last a long time. All right, the requirements for copyright protection. So the first is that it has to be original, right? If you copy somebody else's work, then that's not, you can't get a copyright in it because you didn't originate it. That doesn't mean that you can't be inspired or build upon something of someone else's. That's always the case. But it has to be there has to be original work that's yours in order to get any kind of copyright. And there has to be at least some creativity involved. And it has to be saved on disk or written down on paper, you know, fixed in some kind of media, as we were saying earlier. All right, going on to slide 14. This is a list of the types of works that are protected, and we were already talking about that, right? Literary works, musical works, any kind of creative work. All right, moving on to 15. This slide really explains some of the concepts we were already talking about. You know, a work for hire is something where that's created by an employee or an independent contractor, where they sign an agreement saying it's a work for hire, and then it's owned by the employer. A joint work, just so you know, if there's more than one author that jointly work together to create some kind of creative work, then they jointly own the copyright. They own it together. It's like being joint owners of a home or any kind of property. Okay, now what does it mean if you own the copyright? Protection granted by copyright. The owner of a copyright in some particular work, right, in some particular creative thing, has the exclusive right to reproduce it. That means the exclusive right to make copies. So, you know, it's important to think about the difference between the thing itself and the copyright in it. If I go out and buy a book, I own the book. I bought it, I own it. But that doesn't mean that I can make a copy of it because I don't own the copyright in the book, right? Same if I buy a painting. I have the painting, I own it. I can hang it in my living room, but I can't make a copy of it because I don't own the copyright in it. So the copyright law gives the author the exclusive right to make copies or to license or allow others to make copies. It also gives the author the exclusive right to create a derivative work based on the underlying work. A derivative work is a new work that's based on the old work. So it's based on it to an extent that it includes a lot of the original expression. So it would be an infringement if it's not authorized. In addition to having the exclusive right to make copies, the copyright holder has the exclusive right to distribute copies or sell copies. And then finally, the copyright owner has the exclusive right to publicly display or publicly perform the work. So for example, if you if you show a movie in public, you know, like in your, you know, maybe you operate a restaurant and you have the movie playing in the restaurant, or you operate a theater and you charge people to come and see the movie in your theater. That's infringement unless you have unless you own the copyright or you have a license. You know, you have permission from the copyright owner. Similarly, public display of a copyrighted work, like a still picture, can be infringement. So for example, if you post a photograph, somebody else's photograph, on your social media page so that it's viewable by the public, that's copyright infringement. That is a violation of the law, right? You can't just take someone else's photograph, for example, and post it on your Instagram page. You know, there may be defenses, there may be fair use arguments, which we'll go into in a minute, but fundamentally, that's a violation of the copyright law. All right, going on to the next slide. Copyright has this concept called the idea versus expression dichotomy. It means that copyright protects an expression of an idea, but not the idea itself. So for example, you know, Romeo and Juliet is a beautiful love story. The idea of writing a love story cannot be protected by copyright. But, you know, Shakespeare, particular expression of the idea of a love story, of that idea, you know, his actual play, is protectable. That's an example that's already in the public domain because it was written so long ago. But you see what I'm saying, right? Copyright doesn't protect underlying ideas. It protects the way those ideas are expressed in any particular case. And finally, fair use. There are times when you can defend against a claim of copyright infringement by saying that what I did was a fair use. Fair use is very complicated and it's very subjective, right? Which means that a lot of times even an experienced lawyer won't be able to tell you whether something is fair use, because even though the law, the words in the law are clear, applying those words, actually understanding how they should come, how any particular case should come out, applying the standards, the words in the law to any particular situation or circumstance is difficult. And, you know, smart people can have different opinions in any particular case about whether something should or shouldn't be a fair use. So rather than going into the details of what fair use means, I think the best thing for you to keep in mind is that you should assume that if you copy or distribute copies or do anything else that we talked about that you're not supposed to do, you may be liable. You shouldn't rely on fair use unless you have talked to a lawyer about your particular situation. Copyright notices, you've seen them in books and on album covers, records, right? It's the C in a circle. You don't have to use a copyright notice. A while ago, a long time ago, they were required. They're no longer required. There's no disadvantage to doing it. You might as well put a copyright notice on works if you're publishing some kind of protectable work, but you don't have to. And then, as I mentioned, you can register your copyright, but you don't have to in order to have a copyright. If you want to bring a claim for infringement, then you have to register before you can sue, but that's just an administrative process you have to go through. There are some advantages to registering. The scope of remedies, the kinds of damages you can get are a bit broader. If you've registered your copyrights, you're entitled to something called statutory damages. In some circumstances, you may be entitled to recover your attorney's fees, right? If you sue an infringer and you win, they may have to pay your legal fees under some circumstances. So if there's an important copyright for your business, you should consider registering it. The slide 21 just describes the registration process. You can look at that yourself. There's nothing too significant there. All right. Next, let's move on to trade secrets. So a trade secret, if you look at slide 23, it says that it's protection and it has in parentheses state law. And until very recently, that was right. Trade secrets were only protected under state law. But a few years ago, federal law was passed also protecting trade secrets. So it's called the Defend Trade Secrets Act. So now there's both state law and federal law protection for trade secrets. And, a trade secret, I'm going to go a little out of order. Let's go to the next slide, slide 24. What's a trade secret? Okay, if you look at the top here, a trade secret must, there's two things that have to exist for a piece of information out there to be a trade secret. One, it must be something that's of value to your business because your competitors don't know it. So for example, if you have a lot of really detailed technical information about how to do whatever it is your business does better than your competitors, that could be a trade secret because the fact that they don't know how to do it helps you. Or if you have a lot of information about potential customers or a long customer list, that helps you make sales more effectively than competitors that don't have all that information. That's something that benefits you. It's a piece of information that you have, and it's more valuable to you because your competitors don't have it. So that's the first thing you have to show about a trade secret. It's a piece of information that's more valuable to you than it would be if your competitors also knew it. Okay. The other thing is that you have to make reasonable efforts to keep it secret. Okay. So you can't just sort of leave it outside or leave it, on a desk in your waiting room where where customers or anybody who happens to walk by might see it. You keep it under, if it's written down on paper, you keep it locked away someplace. If it's on a computer, you have it's password protected in some way. And the most important thing to keep in mind about that, in addition to the fact that you have to take reasonable security precautions to protect your trade secrets, is that in order to really use trade secrets, you sometimes have to disclose them, right? Like you have to tell your employees so they can use them in the business. And sometimes if you hire independent contractors to work with you, you have to tell them the trade secret. Sometimes if you partner with other businesses in some way, you have to share trade secrets with them because that facilitates whatever it is you're trying to cooperate with them with, you're working together somehow. In those situations, it's very important that there's an agreement in place where the people who receive your trade secrets agree to two things or three things. One is that they won't disclose it, to anyone else, unless they need to in order to do whatever it is you guys are doing with it, and whoever they disclose it to then has to agree not to use or disclose it. So that's the first thing. The second is that they not only have to agree not to disclose it, but they should agree that they're going to take, reasonable steps to keep it secret. They're going to be careful with it. Excuse me, just have a little water. And then the third is that they should also agree not to use it, except for whatever the purpose was that you disclosed it to them, right? So they can't just use it for anything. So those are the things that you need to keep in mind with trade secrets. And in this slide 24, they have a few examples of the kinds of things that could be trade secrets. Customer lists, training methods, strategies, business plans, formulas, and recipes. Now, going back to slide 23, so a trade secret will be lost if it's no longer secret, right? So if you disclose it to somebody, but you don't get a non-disclosure agreement, then you've lost the trade secret protection. The purpose of the trade secret law is to essentially promote, fair and ethical practices in business, right? Prevent people from competing unfairly with one another. The term of a trade secret is unlimited, like a trademark. It's going to be protected as long as it remains, as long as those two things that I mentioned, it's actually a secret that is of value to you, and you continue to make efforts to protect it. As long as those things continue to be true, it'll continue to be protected. And then this slide mentions what I talked about, the fact that you can disclose it as long as you have an agreement in place. All right, so now moving on to slide 25. There are significant advantages to trade secrets. A trade secret can be any kind of information as long as it's secret and valuable, right? And so it can cover abstract ideas. We had talked about the fact that copyright doesn't protect ideas. It only protects expression. Patents also don't protect abstract ideas. They protect inventions, actual kind of practical inventions. A trade secret protection is also available for information that doesn't meet the high threshold of patentability. So in order to get a patent, your invention has to really be something that's unique and that wouldn't be obvious even to an expert, right? It's not easy to get a patent, but those kinds of stringent requirements don't apply to trade secrets. And trade secret protection is relatively, cheap and easy to obtain. You need to get agreements in place before you disclose them, and you need to take ordinary security precautions, but that's not particularly difficult or expensive. These days, a lot of businesses work from home. And this is something that I can tell you in my business is very important, right? During the worst of the pandemic, really for a couple of years, my law firm, and really all law firms and a lot of businesses, were completely closed. But those were some of the busiest periods of, certainly of my career. There was a lot going on. But we all worked from home. And that meant that, our computers were at home instead of at the, where we were producing a lot of the work, were at home instead of at the office. All of our communications were done over, Zoom or the phone or whatever. And, that raises issues and of course, as lawyers, we have access to very sensitive, secret, trade secret information of our clients that we have to protect, right? That we have an ethical obligation to protect our clients' secret information. We can get in huge trouble if we don't do that. It's very important. And so if you're a business that has, valuable trade secrets, or like a law firm, it has, an obligation to maintain information and confidence, what do you do where that information constantly goes home with your employees, or where they don't come into work at all, right? They work from home all the time. it's very important to identify for employees what you view as a trade secret, right? Your employees, if your employees have access to your trade secrets because they need to in order to do the job for you, right? My clients have to disclose confidential information for me in order for me to do my job, to advise them about, legal issues. It's important to understand what is and isn't deemed confidential, and you shouldn't necessarily assume that your employees will automatically know that. It's important that you tell them. It's useful to ask employees to shred documents that include confidential business information once they're done with them, right? It shouldn't just be laying around on their kitchen table. Don't use personal email to transmit work documents. Don't save information on your home computer, your personal computer. Save information only on storage systems that belong to the company, and use only company computers for business work. And finally, avoid using unsecured sites when sharing documents. So sort of common sense advice about how to maintain trade secrets. Other things you can do, we had talked about taking reasonable precautions to maintain secrecy, and also notifying people when something, your employees, when you consider something to be a secret. So an easy way to do the second one of those, to notify, is to make sure that your trade secret information is clearly labeled as confidential. One thing to keep in mind about that, some businesses go a little crazy. They get a confidentiality stamp and they put it on everything, right? If you if you're a restaurant and you stamp your menu as confidential, it's going to minimize the usefulness of the stamp. You should only use, if you use it everywhere, then it's not going to mean anything. But if you actually use it selectively, when information actually is something that you consider a trade secret, it can be very helpful, because it'll then put people on notice that you view it as this is confidential. You should make sure that, to the extent you have people working remotely, that your systems have strong encryption. Limit access to trade secret information to only those who need to know, right? So, if your company has some kind of secret customer list, and maybe you have an engineer working, the engineer doesn't necessarily need to know the customer list. That's something that your sales team needs to know. Similarly, if you have very, some kind of sophisticated manufacturing process, the people working in the factory might need to know it, but your salespeople wouldn't necessarily need to know it in that case, right? So the idea is, have security in place, even internally. Even internally, your security should make sure that employees who don't need access to certain kinds of information don't have it. Then we had talked about requiring NDAs. A lot of employees now use, in addition to this work computer, phones for emails. You need to make sure that if they use their own personal devices, that you have adequate security in place, precautions in place, so that, your secret information is protected. Or don't let them use their own, issue them, company phones that they're supposed to use for all company business, and similarly for document exchange purposes. So that's the last slide. Can we take, I don't know if there are any questions, or if there's anything that anybody wants to cover in more detail.
So everyone, I don't see any questions on the chat right now, but if you have questions, feel free just to write them on the chat, or just to unmute yourself. Seeing a couple of people just left. So feel free there to write on the chat, or just unmute yourselves. Okay, so I don't think anyone has questions. I'm going to stop the recording now. I don't see the option. Stop recording.